Hi, I'm Steve Carlson. I'm going to read to you a presentation I'll be making to a statewide panel on Monday. This is an argument to the statewide judicial panel on the Franken invalid election. It will be presented 1:30 on the 23rd. Now, the proceedings to date, I will argue to the panel, which by law must be voided, have produced a twisted and Byzantine edict by two Minnesota state courts, which have resulted in Franken being seated and now saying nothing can be done about it. The Minnesota Supreme Court and this panel at the Ramsey County Court, appointed by the Supreme Court in 2014, but not allowed to be constituted in 2012 in similar circumstances with Betty McCollum. These panels must be constituted in the event of a contest such as this, and the panels are tasked by law and Constitution to gather, certify, and forward to Congress, and not to evaluate or judge the evidence of the question of Senate incumbent and now sworn in Al Franken's right to office, or of Betty McCollum in 2012, for reasons of deliberate, material, and serious violations of Minnesota election law. And that's what the instant contest is about. But instead of following the Minnesota law and the U.S. Constitution and election laws and precedents, collecting and forwarding this evidence, these courts have engaged in issuing nearly incomprehensible steps and partial judgments, which most critically have put these courts in the role of judges in this election contest, which they're not supposed to be in. And there are not two contests, there is one contest, and it centers on just one simple matter: the validity which this contest has thrown into question of Al Franken's election in 2014. Not the vote count, but the validity, the soundness and integrity and constitutionality. And the evidence has been systematically suppressed by this panel in 2014 and by the Ramsey County Court and the Minnesota Supreme Court in 2012, and that is in fact one of the grounds to find that the elections were invalid. There are some glaring omissions by defendants. The first two involve circumstances of unlawful issuing of the Franken certificate. Three glaring omissions stand out when reviewing the submissions of defendants March 16th to the instant motion. These submissions by defendants actually do not question the grounds I have submitted for voiding these proceedings. Now, in the first two of these three key omissions, Franken, in his account of the so-called procedural history of this case, omits the date of the issuance by defendant, Office of the Secretary of State, and the Governor of Franken's purported election certificate. This is important for two reasons. First, because of the date itself, which is stated clearly on the Governor's letter and the certificate, and his letter to the U.S. Senate, all of which he sent on December 19th. And the second reason is this certificate is required by the U.S. Senate in order for Senator Franken to have been seated. Now, the letter from the Senate erroneously says that he would be seated on January 3rd, and that is therefore erroneously the same on Dayton's and Ritchie's certificate, and arguably added to the perceived time pressures to get this out there 3 days early during the Christmas and New Year's holidays. Now, Dayton's letter says, his cover letter says, quote, in accordance with 204C.40 subdivision 2. Now that's time requirements, the time when the certificate may not be issued. But he says, in accordance with that, I have prepared the enclosed certificate of election for Al Franken. Now, this is the issuance of the certificate, and it was sent to the Secretary of the Senate immediately out in Washington. And this is countersigned by then Secretary of State Mark Ritchie, who knew, as Franken did, that issues were still pending. The contest was still pending. In your partial judgment, which has no basis in law or constitution, but it is a preliminary order that Franken urges is a, quote, well-reasoned and thorough order, unquote, you do not mention this law once, the time for issuing this certificate. And you allow this order to be issued, but nowhere do you say, quote, we have the power to and hereby do relieve Governor Dayton and Mark Ritchie of the requirements of subdivision 2 of 204C.40. That, quote, and it says, in case of a contest, an election certificate shall not be issued until a court of proper jurisdiction has finally determined the contest, unquote. Yet both Dayton and Ritchie and Franken acted in knowing violation of this law, because it's right on the letter to the Secretary of the Senate, a knowingly false statement signed by the DFL Governor and the DFL Secretary of State. Will Secretary Simon stand by this falsehood, or will he be honest to the U.S. Senate? Do I need to ask if this panel will be honorable in this regard? I hope I do not. I hope this matter is cleared up right away. The Senate needs to know this, along with the other questions about Franken's right to office. Attorney General Swanson urges that, quote, later on December 19th, when appellant had made no request to stay further action pending an appeal, Governor Mark Dayton prepared and signed, and contestee responded. They recognized that the Secretary of State is not just a contestee, he's in this contest as a respondent, but that the Minnesota Secretary of State, Mark Ritchie, countersigned the certificate of election for Senator Franken. Both the contest trial court's decision and the issuance of the certificate were legally correct, and as a result, the instant appeal should be dismissed. Now, this was filed at the Supreme Court, but it's relevant here because it's a position that they've taken in this case. Well, it violated the time requirements of subdivision 2 of 204C.40, so it was not legally correct. And in light of the time requirements of 204C.40 subdivision 2, that the certificate and cover letter not issued during a pending contest, what would be the need for a stay? How was I not diligent in not seeking a stay, plus the fact that I did not know that I had been issued until I read this account at the Minnesota Supreme Court, because it should not have issued. Well, it would be that this panel had the power to suspend the requirements of subdivision 2, or perhaps that it, as a court of competent jurisdiction, had finally determined the contest. It doesn't say in the law part of the contest needs to be determined, or a little part of the contest provision that was carved out by Washington attorneys. And this panel says right in that reasoned, thorough order that it had not been finally determined. Quote, the panel directs immediate entry of a partial judgment, unquote, you wrote. Is that a final determination of the contest? No. You wrote in your last sentence, all contested issues that remain outstanding are hereby reserved, and the panel will issue further orders, plural, as appropriate, unquote. That is not a final determination of a contest. And you did not attempt to suspend 204C.40 subdivision 2 to relieve Dayton or Ritchie of its requirements. So this date the certificate had already issued is highly material, serious, and deliberate violation of Minnesota election law, and calls into question Franken's right to office, and it should not have been omitted from any opposition to voiding this entire proceeding, which is a sham. This is Franken's flim-flam certificate. It certifies that he is willing to refuse to honor constitutionalism in the federal government, and it undermines due process and democracy in this nation. I realize Franken calls this sound and fury signifying nothing, because he has acted by fiat, taking this flim-flam certificate to his colleagues from the 113th Congress and using it as a prop to be sworn in. His hand might have been on the Bible, but his certificate was a fraud. And this is why it has been omitted by his Washington attorneys, who don't mention the date. It is void, and no one denies it. Franken says the Constitution and the laws are all sound and fury, signifying nothing, because he's already been sworn. This is how he leads off his argument. He omits the date and manner of following the certificate issuance requirements and contest requirements prescribed by the state legislature, but he relies on the fraudulent issuing, the unlawful issuance by his top-of-the-ticket colleague, Mark Dayton, and the DFL-controlled Office of the Secretary of State. Another glaring omission is the relevant section of the United States Constitution on which this contest and also this motion is founded. Article 1, Section 4. Now Franken revisits Section 5 of Article 1 and pretends now he's the expert on the requirements of that section, which reserves the judging role for Al Franken and other U.S. senators, not this panel, not the Minnesota Supreme Court or any court. And now he defines that section as he might wish it would read. But Section 4 is still too risky for Franken to acknowledge, because it requires him to acknowledge that he and everyone in the state, including this panel, must follow the U.S. Constitution, which in turn imposes regulations on the state and commits all to follow the election laws prescribed in advance by the legislature, not revised interpretations by this court or the Supreme Court or anyone, including the Secretary of State as the chief elections officer and the governor, during and with regard to an election itself, when that election concerns the U.S. Senate or U.S. House. Perhaps defendants or this panel might address that section today, Section 4, because it is the foundation of a democratic society and Republican form of government. And that's what's at stake here, democratic elections in the United States of America. Franken nowhere presents any argument, authorities, or evidence that the December 18th proceedings, the December 19th unlawful issuance of the election certificate by Governor Dayton, and the final judgment entered December 31st are not void for the reasons presented in the motion, nor does Secretary Simon, who has substituted for former Secretary Ritchie. Thus, the motion to void should be granted. Instead, Franken presents an argument that the motions should not be acted on, because contrary to what this panel allowed and what both defendants urged on December 18th, before the defendants unconstitutionally, unlawfully, and unethically pushed this panel to provide a pretext for Governor Mark Dayton on December 19th for a fraudulent and unlawful election certificate to bring up to the U.S. Senate to avoid the requirements of the U.S. Constitution and Minnesota elections law. Now, Franken and Lori Swanson, representing the Office of the Secretary of State, argue that the U.S. Senate are the sole judges of their elections, returns, and qualifications of their members. Before they wrested that corrupt document from this panel, they insisted that you are the judges, and you have wrongly and falsely and corruptly judged the contest. And the Minnesota Supreme Court, rather than exercising its mandamus, assuming the Supreme Court had done so on receiving my appeal and mandamus request after Governor Dayton had, unbeknownst to me, already issued and sent to the U.S. Senate the unlawful election certificate. The Minnesota Supreme Court has also wrongly and falsely and corruptly adjudged the contest. And that is one of the grounds of the contest, the refusal and failure of Minnesota courts to enforce election laws, making this what I have called the Wild West of election law. In 2012, for want of a $350 filing fee, this court wrongfully blocked a contest in the Betty McCollum case, which addressed some of the same constitutional issues with that House election. In 2014, the Supreme Court allowed Franken to contest the process rather than comply with it. And now, for want of $500, which should only apply if a recount had been sought, has apparently said that they might be acting as if they've adjudged the contest. Notably, however, the Supreme Court mailed to me an order on January 2nd on a Friday, and I received it on a Monday, January 5th, with items that needed to have been fulfilled by 9 a.m. that Monday morning. In any event, impossible, and one day before Franken was sworn in. The argument presented in opposition to a motion to find this panel's actions and proceedings void is that something was appealed to the Supreme Court which they determined. That still would not prevent a motion to void the judgment. And in fact, all that was challenged quite properly was your procedure of a partial judgment. That is not allowed by the contest provision. The partial judgment approach violates the bar against acting as judges in the contest. It's basically a cynical confidence between this panel and the Washington and Democrat league shops. You and the Supreme Court agree that Al can simply refuse to comply with the process, and that all the time which needs to be spent to follow the procedure will be spent instead fighting it and refusing to follow it. And it leads to the present posture where now Franken said, "It's all sound and fury signifying nothing." I did not know on January 5th, that Monday, that any election certificate had even been issued. It was not supposed to have been issued, not until it was reported by Secretary Ritchie and Franken in their briefs to the Supreme Court. I could not submit a brief or get $500 or IFP by January 5th because the order was mailed to me January 2nd and not received until after the time required to fulfill these steps. In any event, for purposes of preventing Al's seating, it would have been virtually moot because nothing could reasonably be expected to happen by the next day, January 6th, in the U.S. Senate. And Al, as a judge, had come down to Minnesota with his Washington attorneys to make sure the process couldn't work. And this is improper for a judge. Secretary Ritchie or Simon admit that no issue except the preliminary order was appealed. Indeed, judgment had not been entered by this panel until December 31st, and I attempted to remedy the situation by filing with the Supreme Court at no later than December 29th, if not before. Ritchie wrote, quote, "In its preliminary order," referring to what they now say has been adjudicated on merits up at the Supreme Court, the trial court also reserved judgment on a further issue raised prior to trial, the question of whether the Secretary is a proper party to appellant's contest. In an order issued on December 30th, the court held that he is not. Appellant does not reference this holding in his notice of appeal, of course filed before that date, nor does it have any effect on the questions he does present. As a result, it is not at issue in the instant appeal, unquote. So it was not appealed. And that's true. But everything is at issue in this motion to void and to remedy and to follow the law and send this evidence, allowing discovery, to the Senate. Now here's the Franken argument. The Team Franken legal strategy in getting Al to Washington is an excellent example of the two-faced approach. Before you get the certificate, take the position that the panel must act on Al Franken's motion that challenges the right of the U.S. Senate as the sole judges of the contest, and challenge the operation of the Minnesota law to collect evidence and forward it to the U.S. Senate. And the Minnesota Supreme Court improperly caused this panel to take that motion up. I was not told about it before our hearing December 18th, and never received it. I had to respond on right at the time on this so-called motion provided to the panel in a letter. I immediately said the action would be void. Then on the other face of the Team Franken strategy, once you've got that certificate in your hand from the partisan governor and attorney general, secretary of state, challenge the right of the court to do anything more about it. It's also called the fait accompli strategy, putting all the power in the hands of the Senate and the U.S. House of Representatives, and now none in the courts. Many of his cases, which he lists in his brief, purportedly call into question the right of the state of Minnesota to regulate its elections at all, as far as contests. Neither strategy deserves respect or legal support under the rule of law or a Republican form of government. It's fundamentally dishonest and destabilizing. But what would have happened if Norm Coleman, ahead in the general election by 312 votes, had taken the positions and conducted themselves against David Lillyhaug and Al Franken that Franken and his Washington attorneys have now, and they had done this in 2008. Well, Tim Pawlenty could have done what Dayton did if Ritchie would have let him, he being the Secretary of State, the Democrat. The difference here is that Dayton is a Democrat, Franken is a Democrat, and Ritchie and Simon are Democrats. Pawlenty is a Republican, as is Coleman. And Ritchie wouldn't have gone along with the caper. But as I've already pointed out, if you insert the two omissions into their brief of the date team Franken, Ritchie, Dayton issued the corrupt election certificate and the text of subdivision 2 of 204C.40, it doesn't work no matter who does it. Unless the Supreme Court has suddenly grown the power to suspend the election laws, not just ignore them and fail to enforce them. Subdivision 2 of this provision bars the issuance of any election certificate in the congressional races once a contest of any kind is filed, unless a court of proper jurisdiction is finally determined. Well, what does finally determined mean in this case? There are two kinds of election contest. It's always relevant who is reported by the canvassing board to have received the highest number of votes legally cast, and as the statute says, is, quote, therefore entitled to receive the election certificate, unquote. But this does not mean that the election certificate can be issued, because the time for issuance is another matter. And again, when the contest is pending, the certificate cannot issue. Any fair reading of the congressional contest statute must conclude that finally determined must mean the whole contest, with the panel sending all the evidence, including the election certificate, to the Senate or the House. And yes, it would require holding up the certificate, even if the facts founding the entitlement to receive it had been established, because it couldn't issue until the pending contest was properly adjudicated, meaning being sent to the Senate. Then the Senate would decide as part of the seating decision or do whatever they wished with the evidence. Or to look at the Adam Clayton Powell case, they could seek to expel Frank, and that action would use this evidence of the election's validity as well. When it comes to invalid elections, Minnesota has said, we will supply this evidence. And the action of refusing to seat the candidate or of taking away a seat or somehow disciplining him or her is all within the scope of the election contest provision, and it should be followed. And then there's the power of the courts. Furthermore, elections are governed by law, and courts indeed do have a role. And in fact, the Senate acts in a judiciary capacity as a court when it judges its own election contests. It so happens in this case, as I told Judge Meslow, because you are not the judges, the Senate is in this contest, the judges. And all you could do is gather and certify the evidence and forward it so the judges could exercise their jurisdiction. You do this all the time. A case can be removed to a federal court. You determine the statute of limitations has run and you are powerless. You must exercise the jurisdiction you are assigned to send the evidence to the Senate, and you must not usurp the powers assigned to others. It's never all up to your discretion. And here you have abused power and abused discretion and acted without jurisdiction and taken actions with no authority, such as suggesting to Franken that you had somehow suspended the time for issuance requirement. And all these things outside the Senate are subject to adjudication in the courts. And none of it is moot, because I intend to run again on the Independence Party primary ballot, or if necessary by petition of some of those 45,000 or so who voted for me, who might sign for me to get on the general election ballot. Jesse Ventura wants to run for president too, as an independent candidate, just like I do. And if we get 5% of the Independence Party, will go on. And all these problems with valid elections need to be addressed by the courts as well. Since there is confusion, there is apparent abuse and arbitrary power by the big parties. And so you need to address this motion, which is, was this action by Franken and Ritchie and Dayton allowed by Minnesota law in a contest? Are the big national parties, the Democrats and Republicans, allowed to exclude major political party nominees from publicly broadcast debates for a whole election season or general election? Can the right to vote in caucuses and conventions be denied because of the voter's race or sex or sexual practices? Can candidates and voters get access to those voter emails for political and election purposes, as Office of the Secretary of State employees said they had for years? Can issues outside ballot questions be brought to the Minnesota courts of violations of prescribed election laws or constitutional or federal requirements when those are alleged? Will the state follow its election laws prior to Senate or House action and comply with the requirement to forward evidence? All of these are among the questions to be decided in this motion and by the Minnesota and United States Supreme Courts as well. It is indisputable the Minnesota legislature can and had to create a role for the Minnesota courts which it prescribed to be carried out, including to enforce its other election laws, not just ballot questions, as the Supreme Court has improperly sought to limit it to. Now, why would the Senate or U.S. Supreme Court care about any of the grounds of this election contest and of the election petitions brought to the Minnesota Supreme Court regarding an election for Congress? Well, suppose in the 2014 Senate race, women had been categorically barred from voting. So we took the vote of men and Franken lost, hypothetically. Would this be a personal problem of Franken's? Would he be asserting a mere sore loser personal injury of a right if he challenged the validity of the election he lost because the polling judges excluded all women? Or would it be his duty as a leader to bring this contest of this kind of an election? Would the winner of an all-male election in 2014 be qualified to be a member of the Senate just because Minnesota allowed such a practice? Isn't that something the Senate can judge, where in a seating or any kind of decision to expel or discipline or to otherwise regulate the elections regarding whether high vote getters in these kinds of elections are actually qualified? Yes, it says so right there in Article 1, Section 5, which Team Franken has now found, after they got fellow Democrats to ignore the law and give him his election certificate. Even though this panel, as I explained above, didn't say they could, didn't say you had finally determined the contest, or claim the power to suspend the operation of Subdivision 2 time requirements. In elections, there's quantity, the vote count, and there's quality. And both are regulated by our Constitution and federal laws and Minnesota election laws. Do you think the U.S. Senate would have a concern about the requiring the collection of all evidence and forwarding that evidence to the U.S. Senate so that body could take a vote on whether to accept the raise based solely on the person receiving the highest number of male votes? Or suppose only Democrats had their votes counted. You could imagine the howls before this panel and the demands to the U.S. Senate to exercise their power to invalidate and reject these elections, to abridge or deny the vote of a category of voter based on gender alone, or race alone, or sexual practice alone, or in combination, violates the 15th and 19th Amendments, and the First Amendment right to association, free association during an election. In September of the 2014 election, the record shows I contacted the Duluth News-Tribune, who was organizing Al's first debate on October 1st. And the organizer left a message on my phone, and you can listen to it at my YouTube account. In it, you can hear Chuck Frederick, the Duluth News-Tribune editor, telling me that the organizers decided long ago, not with respect to me as the nominee, that it would not invite the Independence Party to any of its debates. And the endorsed IP governor candidate, Hannah Nicollet, was also excluded, and at one point hinted she would sue Hamline University, with Mark Jenkins, the IP employee who opposed my nomination, standing right behind her. Only Democrat and Republican candidates could get their party's nomination or positions out, not Independence Party, because they felt all the seats in the Senate, or virtually all, were held by Democrats or Republicans, and that's who they wanted to include. And it turns out Al had done this for every public broadcast debate for 2014 for the general election. In another ground, the evidence of record unopposed None of this is opposed by defendants shows that for years, Nancy Breen in the OSS, the Office of Secretary of State, had people fill out forms to obtain email addresses of registered voters. This is not something I dreamed up, that, hey, wouldn't it be great if I could use all the email addresses of registered voters provided to the Secretary of State? I was repeatedly offered this, and in 2012, I filled out the paper and I paid for it. It was part of my strategy. Betty McCollum, my opponent, had asked publicly that voter email addresses not be given to her primary opponent, Diane Longreen. I had started to challenge why the DFL was excluding white male voters with quotas, and intended to email that video and text all around the 4th Congressional District. This is far worse than just tearing down a few lawn signs. This is about blocking criticism of these unconstitutional quotas with messages which would have penetrated the voters' media environment more effectively than 30-second soundbite ads on TV. Now suppose a woman complained to the Minnesota Supreme Court and said, the polling judges are excluding women from voting. And the Minnesota Supreme Court said that, well, under the law 244B, as we have interpreted it, we will not enforce anything but ballot decisions. So the vote went ahead and women were excluded. Don't you think one of the grounds of the contest on which evidence should be allowed to be gathered, certified, and sent to the sole judges, the U.S. Senate, would be, why won't the Minnesota Supreme Court regulate this? You bet it would. And suppose a woman candidate running against Betty McCollum wanted the Supreme Court to review this poll judge practice of excluding women voters. And she made a video about this and wanted to send it all around the 4th Congressional District and say to Betty, you should not get one woman's vote because you support excluding all women voters. And then Ritchie came in and said, you know, we've been doing it all wrong all these years. You can't send that message. And I know Betty's a woman and would not like women votes excluded. Well, I don't want male votes excluded either. If the DFL or Republicans or poll judges did this, the U.S. Senate would care. They would not just want canvassing numbers. Suppose Betty's female opponent wanted to challenge this practice in debates and find a way to discuss the concerns of women voters, but it was blocked. Or Republicans were blocked from debates because they were not going to vote anyway. I have presented a number of key problems with conduct of Minnesota elections that show a pattern of the subtle abuse of power. Abuse of power in elections with a velvet glove and a stone hand. Don't stand in the way of bringing this to the Senate. Nor is the Senate's power restricted merely to swearing in Al Franken on a falsified election certificate, which was contrary to the sworn and sealed statements of Mark Dayton and Mark Ritchie, that it was not issued or sent to Washington in compliance with Subdivision 2 regulating the time of issuance. They can expel or discipline. They can make findings about the validity of election practices. In fact, they have a duty to regulate elections for their body, in addition to judging. As in Ex parte Yarborough, they punished those who blocked blacks physically and with intimidation from voting in Georgia during or after the Reconstruction era. And they have this power, said the U.S. Supreme Court, because the right to vote for members of Congress is enshrined right in Article 1, Section 4, which I have reminded you of. And in order for that right to be upheld, you and everyone in Minnesota needs to follow the laws prescribed by the state legislature, including the Minnesota Government Data Practices Act, which makes voter emails public information, as all the laws existed prior to the kickoff of the 2014 elections and now prior to the 2016 presidential elections. Election by fiat. But, says Tim Franken, hold it. Al was sworn in, and that's final. They have a legion of cases saying all judicial proceedings must stop because the Senate has acted. Well, first of all, the power of the Senate doesn't kick in only after it acts. It's all the time, and it was true also on December 18th when Tim Franken denied it. And if you look at these cases of Tim Franken, you'll find a range of circumstances about what a state can or can't do in its courts or even its legislatures. And yes, election by fiat is also there in those cases prominently. I can't take seriously that the panel would agree that Franken could get his certificate, run up to the Senate, suppress all the evidence here at the panel, even that which was taken on the record, stop all discovery, run to the Senate in disregard of our time requirements for issuing certificates, and then bar any remedy unless I posted $500. And in fact, the Supreme Court acted on a partial summary judgment, which was moot, because the certificate had in fact already been issued on December 19th. And it was not feasible that some action by the Minnesota Supreme Court would change that by January 6th. In point of fact, I never received this order of January 2nd until January 5th after 9 a.m., when all the last-minute requirements of the Supreme Court needed to have already been fulfilled according to that order. It was logically impossible. And most notably, by creating all these schemes as part of the contest, including requiring payments of $500 to get the state courts to follow their legal and constitutional duty, you are acting as judges, which you may not do, not of the contest. So not only the entering of an opinion on this matter is precluded by law, but also procedural actions by the courts that interfere with the evidence getting to the right judges, the Senate, is the kind of judges you are precluded from doing. This is the end of part one of my argument to void the sham proceedings by which Mark Dayton and Mark Ritchie got Al Franken an unlawfully issued election certificate. I'll present these arguments at court on Monday.